Today we are discussing the difference between natural persons and the various permutations of juristic persons or legal entities. Very briefly, a natural person in South African law is, of course, a human being who becomes a person upon birth and remains that until death. There is an interesting exception to that rule, what is basically an inheritance from the Roman legal history or inheritance. The maxim was nasciturus pro iam nato habetur. Literally, it is a fiction that an unborn child is deemed to be a person. I call this a fiction because there is a very limited application of this common law fiction, which is mostly applicable when determining the heirs or beneficiary in our interstate law of succession. In other words, interstate would mean where a person died without leaving a will or a testament, and the succession of heirs are then to be determined. This is an exceptional application and only used in very specific instances. Of course, another requirement to be a natural person is that people, human beings, a natural person reaches the age of majority or full legal capacity, therefore being able to act, acquire rights, to incur obligations, unassisted by a guardian, would be at the age of 18. Previously, in the past, it used to be the age of 21. Legal or contractual capacity of a natural person may, of course, be restricted or even completely removed by the High Court and the High Court only in the Republic of South Africa, in, again, numerous clauses of certain instances where a person becomes physically or mentally disabled. For example, a person who becomes mentally disabled through injury or illness. In such instances, an application could be brought to the High Court for a person to be declared incapable of managing his or her own affairs, and a so-called curator would be appointed to manage the affairs of this person. Generally, the person who is thus appointed is then referred to as a curator ad personam. Then, of course, when we get to a juristic person, there is a significant difference, because a juristic person is not, of course, one single human being. It is a social entity, a community, or an alliance or association of natural persons, which has its own independent legal existence. This association can then be the bearer of judicial capacities and subjective rights, and the accompanying legal entitlements and obligations, exactly like a natural person's or a natural person would have it. This association is independent of the natural person's or people who are then the members of this alliance. But the association would act through these members. There are, in general, three categories of juristic persons which are recognized in our legal system. Now, the first of it is associations established by way of separate legislation, acts of parliament. Certain associations are constituted exclusively with governmental permission, usually where the government has a significant interest or stake in the operation of those associations. Some examples of associations incorporated in terms of specific legislation would be universities, semi-state organizations. ESCOM is another good example. Another example is the South African Broadcasting Corporation. Then the second category would be associations incorporated in terms of very specific enabling legislation. Associations incorporated by general enabling legislation have, of course, legal personality. And it's generally controlled by government in the interest of society, but the main requirement or specific requirement would be registration in terms of the provisions of this legislation, which would then lead to its creation. And it is called registration and or incorporation. Now, of course, those are well known, and some examples are companies which are then incorporated or registered in terms of the 2008 Companies Act. Closed corporations were another good example. Registration took place in terms of the Closed Corporations Act of 1984. Now, of course, it must be understood that it is not anymore possible to register a closed corporation simply by virtue of the fact that the 2008 Companies Act revoked the possibility of a registration of closed corporations. Closed corporations which had been registered prior to the commencement of the 2008 Companies Act, of course, continue to exist. In the 2008 Companies Act, provision was made for the conversion of closed corporations to the structure of a company, mostly then, of course, a private company, or as is colloquially referred to as a PTY Limited. Now, of course, banks is another good example, and banks attain legal personality in terms of the provisions of the Banks Act, Act number 124 of 1993, upon date of registration or incorporation in the offices of the Registrar of Companies. Another good example is that of cooperatives, in terms of the provisions of the Cooperatives Act, number 91 of 1981. Now, the interesting one is associations which comply with the common law requirements for the establishment of a juristic person. Now, this is a lesser known animal, but an interesting one. And this is an entity which could be and become a legal persona in its own right if it came into existence in terms of the common law, in other words, the law that we inherited all the way back from the Roman legal system. So in terms of the common law principles, and not in terms of the process of incorporation or registration provided for in the Companies Act. These associations are known as so-called Universitates, The singular form of that would be Universitas, with, of course, very specific requirements to qualify as such. The first one would be the association must have members, and always. The implication would be the moment that this Universitas cease to have one single or two members, then of course it would cease to exist simply by virtue of the fact that it cannot exist if it does not have members. Now, the second requirement, of course, is the association must have continuous existence, even though the people controlling it may differ from time to time. Historically, of course, it had widespread use as Universitates by non-profit organizations as a way of cheaply or inexpensively creating a legal entity that would not be subject to the vast and considerable compliance requirements imposed by the Companies Act. But it can nevertheless hold funds and property in its own name and own right, and of course enjoy perpetual succession. The third requirement is it must have rights, obligations, capacities, and activities completely separate from its members. Another requirement is its objects must not be for gain. You cannot conduct business for gain, in other words, to make a profit in a Universitas. If the object is for gain, then of course this organization or association would have to be registered as a company in terms of the 2008 Companies Act for it to attain a legal persona. Another requirement is it does not have to have a memorandum of incorporation as is required in the instance of a company, and that would comply with the Companies Act. As a matter of fact, its constitution does not even have to be in writing, so long as its terms make clear and abundantly clear, it must be unequivocal, that it is a legal persona. It chooses to be that in its own right. Now, some of the examples, of course, are everyday use: churches, political parties, trade unions, or labor unions. The legal nature of such an association and whether it is a Universitas is, of course, determined by its constitution, whether it is in writing or not. For example, it was recently held, recently in the sense that it was in 2010, in the matter X TRTC, United Workers Front, versus the Premier of the Eastern Cape Province, and that matter was reported in the law reports, where it was specifically held that a Universitas, and I quote, will come into being if the individuals who propose forming it have the serious intention to associate and are in agreement on the essential characteristics and objectives of the Universitas or unincorporated association. The latter aspect is usually manifested by the approval and adoption of a constitution, unquote. A Universitas, being a legal persona in its own right, has the capacity to own property in its own name, enter into contracts in its own name, can litigate in its own name, and will continue to exist notwithstanding changes in the membership of the Universitas as members as and when they join and leave the organization. Now, lastly, of course, we also use trusts and partnerships in our economic environment. Those are not legal persons. The trustees and partners of a trust and a partnership are mostly personally liable for the liabilities of that entity. Although it must be said that limited personality is bestowed upon it by virtue of other pieces of legislation. A good example of that is the Trust Property Control Act, and then, of course, the Income Tax Act and such. It's an interesting phenomenon, but there you have it. That's briefly the differences of those various entities.